Welcome to the deep dive. We grab the sources, find the core bits, and basically give you the quick version.
Get you informed fast.
Exactly. So today, we are really focusing on just one thing, this recent executive order from the White House. And it unpacks a pretty significant moment for TikTok here in the U.S.
Yeah, it's a really interesting peek into how the executive branch is dealing with a big piece of legislation from Congress. This one document, this EO, is what we're using today.
Right.
It shines a light on the law itself, why the president apparently felt the need to step in, and what that action actually means, but only based on what's written in the order.
So that's our mission.
Yeah.
Get inside this executive order. What's it telling us about that law Congress passed? What does the order itself say about why the president took this specific step? And what can we pull out from just this text about the implications?
Okay, let's do it. Where should we start? Maybe how the order frames the law.
Yeah, let's start there. The order jumps right in, mentioning the law by name.
It does. It references the Protecting Americans from Foreign Adversary Controlled Applications Act. Quite a mouthful.
It is. Sort of the app ban law, as people might call it.
Yeah.
And the order is pretty clear about who the act targets, right?
Oh, absolutely. It doesn't really mince words. It says the act regulates applications, specifically those operated by TikTok and any other subsidiary of its China-based parent company, ByteDance Ltd.
Okay, so TikTok and ByteDance named directly.
Named directly. And it adds that this is explicitly on national security grounds. So the document sets the stage immediately. Here's the target, here's the stated reason.
Right. So the law, as this order describes it, is about apps from foreign adversaries, specifically TikTok, ByteDance, for national security reasons. What does the order say the law actually does? What does it stop people from doing?
Good question. The order gets specific here. It points to Section 2A of the Act. And it says that section prohibits entities from, quote, distributing, maintaining, or updating these apps.
Distributing, maintaining, or updating.
Yeah. And the order even gives examples of what that means in practice. Things like providing services for such distribution by means of an online mobile application store or other marketplace.
So like the Apple App Store or Google Play.
Exactly. Or it also mentions providing internet hosting services.
So the companies that actually host the data keep the platform running online.
Precisely. So according to the Act, as cited here, those service providers basically can't support the app in the U.S. anymore.
Okay, that's pretty comprehensive. And did the order mention a specific date when all this was supposed to happen? A deadline?
It did. Crucially, the order states very clearly that Section 2A of the Act, those prohibitions we just talked about, became effective on January 19th, 2025.
January 19th. Okay, now this is where the document really pivots, right?
Yeah.
It connects that date to the president's own situation.
Yeah, this part is, well, it's pretty striking. The order starts this section by talking about the president's unique constitutional responsibility for the national security, foreign policy, and other vital executive functions.
Setting the stage for why the president might need to act.
Kind of laying the groundwork, yeah. And it also acknowledges the scale here. It mentions TikTok is used by 170 million Americans.
That's a huge number.
It is. And the order then states the president's goal is to protect national security while saving a platform used by 170 million Americans. So it suggests a desire to find some kind of resolution, maybe not just an outright ban immediately.
Okay, so protect security, but maybe save the platform. But then comes the timing issue.
Yes, the order literally says the unfortunate timing of Section 2A of the Act. Unfortunate timing.
That's direct language for an official document.
It is, and it explains why it's unfortunate. It notes that the effective date, January 19th, was one day before he took office as the 47th president of the United States.
So the ban kicks in January 19th, the new president takes office January 20th. One day.
Exactly, one day.
Why does the order say that specific timing was a problem? From the president's perspective, obviously.
The document spells it out pretty clearly. It says, this timing interferes with my ability to assess the national security and foreign policy implications of the Act's prohibitions before they take effect.
Didn't have time to review it first.
Right. And it also says it interferes with my ability to negotiate a resolution to avoid an abrupt shutdown while addressing national security concerns.
So no time to assess or negotiate before the deadline hit.
The order lists things the president needed time for, like consult with my advisors, review sensitive intelligence, and also evaluate the sufficiency of mitigation measures TikTok has taken to date.
Mitigation measures? Like things TikTok might have already done to address security concerns.
Presumably, yes. The order suggests there wasn't time to evaluate those properly before that January 19th hammer fell, so to speak.
Okay, so the argument laid out in the order is that the effective date, happening right at the transition of power, basically short-circuited the new administration's ability to do its due diligence before the prohibitions potentially went into effect.
That's the picture the document paints.
All right, so given that problem described in the order, what does the executive order actually do? What's the core action?
The main action is pretty straightforward. It pauses enforcement.
Pauses it.
Yes. The order directs the Attorney General not to take any action on behalf of the United States to enforce the act for a period of 75 days from the date of this order.
Okay, 75 days, starting from the date the order was signed, which was January 20th, 2025. So a 75-day pause on federal enforcement.
Yeah.
And what's the stated reason for this pause?
The order says it's to permit my administration an opportunity to determine the appropriate course of action with respect to TikTok.
Okay.
And it adds, to do this in an orderly way that protects national security while avoiding an abrupt shutdown.
Orderly way, avoid abrupt shutdown. Makes sense. Now, the scope of this non-enforcement seems really important, and the order gets quite detailed, doesn't it?
It really does. It's not just about future actions during those 75 days.
Right.
The text says the Department of Justice, the DOJ, shall not take any action to enforce the act or impose any penalties for non-compliance. Like distributing the app. But then it adds this really crucial part. It says, even after the expiration of the above specified period, so even after the 75 days are up, the Department of Justice shall not take any action for any conduct that occurred during the above specified period or any period prior to the issuance of this order, including the period of time from January 19th, 2025 to the signing of this order.
Wow, okay, so let me unpack that. It covers the 75 days after the order was signed.
Correct.
And it explicitly covers the time before the order was signed, specifically that one-day gap between the act becoming effective on January 19th and the order being issued on January 20th.
Exactly right. So the order essentially says no federal penalties for anything that happened regarding this act between January 19th and the end of that 75-day pause.
Right.
It's retroactive for that initial period.
That seems significant. Making sure nobody gets penalized for that window when the law was technically in effect, but the new administration hadn't acted yet.
It seems designed to prevent exactly that, and the order reinforces this by telling the Attorney General what to do next.
Okay, what follow-up actions are required?
Two main things mentioned. First, issue written guidance to implement the delay. Pretty standard. But second, and this is important, the AG must issue a letter to each provider stating that there has been no violation of the statute and that there is no liability for any conduct that occurred during the above specified period, as well as for any conduct from the effective date of the act until the issuance of this executive order.
So a formal letter saying you're okay for this period, no federal liability.
That's what the order mandates, a kind of assurance to the entities affected, like app stores or hosting services.
Got it. Okay, let's switch gears slightly. The order also talks about who gets to enforce this law, right? Enforcement authority.
Yes, and this part is very direct about power dynamics. The document points out that Section 2 of the Act vests authority for investigations and enforcement of the Act only in the Attorney General. Emphasis on only.
So the order is citing the act itself to say that enforcement power belongs exclusively to the Attorney General, who is part of the executive branch.
That's precisely the argument it makes. It's saying federal law gives this job solely to the DOJ.
And does the order say anything about, say, states or other groups trying to enforce the act?
It does, and the language is strong. It calls any attempted enforcement by the states or private parties an encroachment on the powers of the executive.
Encroachment, that's a loaded term.
It really signals the executive branch's view that this is their domain, and others trying to step in would be overstepping.
So a clear line drawn in the sand, according to this document. And does it tell the Attorney General to actively defend this position?
Yes. It instructs the AG to exercise all available authority to preserve and defend the executive's exclusive authority to enforce the act.
Okay, so defend that exclusive federal turf.
The message from the order seems to be, this law's enforcement is federal, it's the AG's job, end of story.
Interesting. All right, and just to wrap up the details of the order itself, there are some standard clauses at the end, general provisions.
Right, the sort of boilerplate stuff you often see. It clarifies the order doesn't mess with the authority of other executive departments or agencies.
Like, it doesn't change the Secretary of State's job or anything.
Exactly. And it also doesn't affect budget stuff handled by the Office of Management and Budget, the OMB.
Standard administrative points.
Yeah.
And it also mentions legal rights.
Yeah, it includes a common provision stating the order is not intended to and does not create any right or benefit enforceable at law or in equity by any party against the United States.
Meaning, like, TikTok or an app store can't sue the government based on this order saying their rights were violated.
Correct. It frames the order as an internal directive within the executive branch, not something that creates new legal claims for outside parties against the government.
Okay, good clarification. So let's just quickly recap what we've pulled directly from this document.
Sounds good.
We saw how the order describes the app ban law targeting TikTok ByteDance on national security grounds, set to take effect January 19th.
Right. Then we saw the president's perspective as presented in the order that the January 19th timing was unfortunate because it didn't allow time for assessment or negotiation by the incoming administration.
Which led to the core action in the order, delaying federal enforcement by the Attorney General for 75 days, starting January 20th.
And crucially, that non-enforcement explicitly covers conduct back to January 19th, the day the act took effect, but before the order was signed. Plus, the requirement for letters confirming no liability for that period.
Yeah, that retroactive aspect is notable. And finally, the order's strong assertion, citing the act itself, that enforcement authority lies exclusively with the federal Attorney General, calling other attempts an encroachment.
So yeah, sticking strictly to the text gives us that specific narrative and justification from the executive branch's viewpoint.
Exactly. Which leads us to our final thought for you, the listener, just based on what this document lays out. This executive order meticulously details a sequence law passed, timing conflict identified, executive action taken, enforcement authority defined. Thinking only about this text, what does it suggest about how the executive branch sees its relationship and maybe its necessary powers when dealing with laws passed by Congress, especially when tricky issues like national security collide with something as massive as a platform used by 170 million Americans?
It certainly presents a specific case for executive action and prerogative, using the timing and the need for orderly process as its main justifications.
Definitely food for thought on the checks and balances described within this one official document.
Indeed.
Okay, that's our time for this deep dive focusing solely on this executive order. Hopefully, breaking it down this way helps you understand the specific points and arguments presented within it.